Hello and welcome to episode 5 of Plaintiff Prep. At this point, you signed on with an attorney and your attorney has engaged in pre-suit investigation. The next step is for your attorney to draft a demand package to the insurance company of the liable parties. The point of this video is to help you understand what a demand package is and the various components of a demand letter.
A demand letter is a letter your attorney will send to the insurance company, which is basically a demand for payment before your attorney files the lawsuit. The reason a demand letter can be crucial to your claim is because if the insurance company accepts, you don't have to move forward with a lawsuit. Now, let's talk about the demand letter itself. A demand letter typically contains the 4 following elements. 1, the known facts of the case. 2, your liability argument. 3, a presentation on damages. And 4, a settlement demand with a time limit.
As we talked about before, the demand letter will discuss the facts known at the time before the parties engage in discovery. Typically, the demand letter opens with a broad statement of how, when, and where your accident occurred. It also notifies the insurance company that there are records included in the demand package which help substantiate your claim.
Now, let's talk about liability. The liability section of a demand letter typically begins with a more in-depth discussion of what occurred on your date of accident. Additionally, this section may include citations to case law and Florida statutes that you and your attorney believe the defendants violated. Simply put, this is where your attorney will establish that the defendant owed you a duty and that the defendant breached that duty.
Let's talk about damages. As we briefly discussed in episode 2 on Consultations, damages is about quantifying how much money you deserve for the harm the defendant caused you. In the demand letter, your attorney will likely draft a narrative which may highlight different categories of damages. These categories may include past medical expenses, future medical expenses, past lost wages, loss of future earning capacity, as well as past and future pain and suffering. We'll dive more deeply into each of these categories in future videos.
Finally, let's talk about the time limit demand. In the demand letter, your attorney may include a settlement demand with a cutoff date. If the insurance company accepts the settlement amount and sends your attorney a check before this date, the case is pretty much settled and your attorney will not need to file a lawsuit. If the insurance company rejects the demand or does not send a check before that date, your attorney will likely proceed with filing the lawsuit.
It's important to note that most insurance companies will require you to sign a release before you get the check. This release stops you from pursuing the same claim against that insurance company and defendant in the future. In return for releasing those future claims, you get paid. We'll talk more about releases in future videos.
Thank you so much for joining us for another episode of Plaintiff Prep. Tune in for the next episode where we're going to be talking about filing the lawsuit.